lot to St. Francis de Sales, and especially to Jane and to Lydia for convening the series and for giving us an opportunity to speak about I'm going to call it the criminal law system. That's usually the language I use when I teach, and anyone who kind of reads or works in this area will know a reason why is because many people don't believe it really is a criminal justice system, that the problem is there's actually a lot of gaps. So I'm going to kind of tend to use that language throughout. I also am a professor, so I have notes, and our seasoned criminal defense and now court attorney, Christina Garcia, is going to be the more seasoned that notes. So I think we'll make a nice pairing. So I want to begin tonight by just asking everyone to close their eyes for a moment. And I want to invite us to think about what comes to mind when you hear the word criminal. Or when you hear that this person has a criminal record, or this person has or is currently serving time in prison. Who is this person? What characteristics or traits do they have? How do they make you feel? What are you more or less likely to do in their presence? What do they look like? Where are they from? And where are they going? So I want us to keep a little bit of those starting points in mind and see how we think about maybe some of those same questions at the end of this evening. And when we think about criminality, we're reminded that there are few social or legal categories that provoke as much hostility, fear, and loathing as the criminal. So even for those of us who have personal or professional experience with the criminal law system, perhaps we have visited a family member or ourselves have served time in custody, perhaps people have served in prison ministry, or perhaps we simply follow debates about mass incarceration in the US or the disproportionate incarceration of Indigenous peoples in Canada. Even for that group of people who might be slightly more kind of experienced with the criminal system, our views of the criminal tend to reflect deeply ingrained ideas that the criminal law properly defines who is in and who is out, who is safe and who is dangerous, who is worthy of a job versus who can't be trusted, who deserves social housing versus who has exhausted all their chances, who should be allowed to parent, and who should be denied child custody or even access and visitation altogether. And in the few minutes that I have before Christina shares her experience working in the criminal system here in New York, I want to challenge some of those assumptions. And I want to do so by analyzing the criminal law system as a system. That is, as a set of interlocking actors and institutions that mark some people and populations as criminals, while leaving unexamined other forms of structural wrongdoing that have catastrophic ecological, economic, and human costs. And in doing so, I want to focus specifically on the ways in which poverty, which is closely associated with race and immigration status, figures centrally in who our society convicts of crimes and therefore who we mark as criminals. So to analyze these disparities and kind of think them through together, I want to start with the kind of basic mechanics, nuts and bolts of our criminal system, right? So how does it work? So many of us may have grown up or continue to watch our favorite crime series, Law and Order, or Dateline, or if you're aging yourself, maybe Matlock or Perry Mason. I was huge on Matlock as a child. Or you're a more like current viewer who is viewing true crime on Netflix, maybe again, you're dealing with stuff, OJ, or Casey Anthony, or whatever, right? In any case, we see a pretty familiar script that plays out, right? So you have the police, and they kind of encounter the accused. Usually they've done some really great investigative work. They've gathered the evidence. They obviously read the accused, his rights, right? You have the right to remain silent. Anything that you say can and will be used against you in a court of law, right? So we kind of know all that. And then it goes on, and what happens, of course, the accused has his or her big day in court. They go to trial, a judge or jury decides their fate, and then eventually, if they're found guilty, they're sentenced by a judge, and they kind of disappear, usually into the penal system. The reality, though, in fact, is very different, right? And Christina obviously knows this. We don't have a system of trials. What we have in the US and Canada is a system of plea bargains, right? Where people overwhelmingly plead guilty to crimes before and without standing trial. So in both the US and Canada, estimates are about over 90% of cases resolved without a trial. In the US, 97% of federal convictions and 94% of state convictions are based on guilty pleas. In Canada, the numbers are a little less, but pretty similar. In Canada, acquittals after trial only represent about 3% of total cases, okay? So why does this matter? You may think, well, maybe this is all good, right? It's more efficient, it's less expensive, right? It's quicker than running a trial. Maybe you've heard this, it's a very common line, and this is true, it will spare the victim, right, from having to relive maybe a horrific incident by having to testify in trial, right? And the guilty person will, if they're guilty, truly guilty, they'll accept responsibility for what they've done. They'll immediately start serving their sentence, and then they will be able to eventually re-enter society, right? And these are features that you will hear many people who support the status quo really emphasizing. But I want to also draw us to a much darker side of this plea bargaining system, and particularly several structural features of our current criminal law system through plea bargaining that dramatically disadvantage the poor, including and especially defendants of color, Indigenous defendants, and people with mental illness and addiction. And I'm going to return to that disparity point first. I just want to spend a few minutes talking about how did we get here. Why do we rely so much on plea bargaining versus our kind of idyllic vision of the trial? Well, one thing to keep in mind, of course, is the sheer volume of activity that we channel through as a regular day-to-day affair in our criminal courts, right? If we were to go to trial on every charge that we had, the system would break down in half an hour, right? It would just be over. You just would not be able to process what it is. But another less noticed feature, and this is where things get a little complex, but just stay with me, is that there has also been a modern legal trajectory that has contributed to this overwhelming reliance on plea bargaining. And this goes back to those due process warnings that you see on Law and Order, right? So this, remember, when the police puts the guy in cuffs, you have a right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to a lawyer, etc., etc. Those warnings and that set of rights that we give to accused persons, they really came into being in the 1960s here in the US. So in the 1960s, the U.S. Supreme Court, under Chief Justice Earl Warren, interpreted the U.S. Constitution to provide a series of rights to accused persons, okay? And that's what we call, they'll sometimes refer to as due process, right? And likewise in Canada, you saw a similar thing. In a few decades later, we had the Canadian Charter of Rights and Freedoms brought in 1982. Our criminal accused likewise started going to court and saying, hey, I have these constitutional rights. You need to overhaul your system. You need to curb bad policing. And our Supreme Court also read in a number of rights for accused. So you have things like the U.S. Supreme Court under Warren said that under the Constitution you have a Fourth Amendment right against unreasonable search and seizure. If the police were to bust into your home without a warrant, they start rummaging around, they find some drugs, and they seize those drugs, the Warren Court said, hey, that will violate your Fourth Amendment rights. They can't use that at trial because it violated your Fourth Amendment right. Okay, it's going to be automatically excluded. Likewise, the famous Miranda warnings that I'm referring to, you have the right to remain silent. That is decided in the 1966 case. What that means is that the prosecution cannot use statements that you make to police if they don't read you your rights. They can't use those at trial. Okay? And remember, just keep that in mind, that's at trial. They can't use the drugs they illegally find at trial. Right? The Supreme Court has stepped in. It's not difficult to see why. This was the 60s, this is the height of the civil rights movement, and many believe that extending these greater constitutional rights to accused persons would significantly close the justice gap between the rich and the poor, and between whites and African Americans. One legal scholar at the time wrote in the Michigan Law Review in 1968, the gulf between the illusion and reality of constitutional protection has narrowed. The quality of justice meted out to the poor more closely approximates that available to the rich. And then he thought, we're going to stop seeing a kind of two-tier system now that we have these constitutional rights. In reality, as we sit here today in 2019, many of us are aware that that has certainly not come to pass. As a first point, you have to keep in mind that these rights that the accused has, they don't kind of come into being in themselves. You have to claim them. So we know that poorer and less sophisticated defendants are far less likelier than wealthy defendants or accused people who have more serious, longer-term involvement with the criminal system. The latter group are much less likely to insist on their Miranda rights and refuse to speak to police or refuse to speak without an attorney than the latter, right? And so if you waive your right, that's game over to begin with. But there's also a more structural account for why constitutional rights have not closed the gap. And here we're going to return to this question of trials that we opened with. The late criminal law scholar Bill Stuntz noted in his book, The Collapse of American Criminal Justice, which I highly recommend for anyone interested in reading further, that before the 1960s, so before this Warren Court revolution in rights, between 1/4 and 1/3 of state felony charges led to a trial. Today, that number is just 1 out of 20, right? So you had far more people going to trial before this rights revolution than today, okay? And why might that be? Well, one of the reasons that Stuntz argued is that more rights protection for the accused has actually contributed to less matters going to trial. Right? Why would that be? Why, if you get more rights at, arrest or detention, would you have less trials? Well, the first thing is that the accused obviously can make more rights arguments at trial if they have rights, and that therefore means the trial goes longer, right? So let's use our example of the police search. If the police bust into a house without a warrant, they search, they find drugs, or if they go into a house under a warrant for one matter, but they find other things, if there's any dispute about a search of a home at all, unless it's like really close or shut, the defense, if they went to trial, will try to argue that it was an illegal search. I mean, why wouldn't you? If you go to trial, you'll try to run every argument you can. That makes it a longer trial, more complex, right? And also note that the remedy that I talked about when the police violate these rights is that the evidence isn't used at trial. Right? So the prosecutor can still go ahead with charges. They just know that ultimately, if it goes to trial, they can't use that evidence. Okay? So what happens, right? Now we potentially have longer, more complicated trials, maybe more rights arguments are being made. So we could have seen one response. One would be that people would look at the system and say, hey, trials are getting longer, they're getting more complex, and there are a few reasons why that happens, but one is because of these rights arguments. What we're going to do is we're going to fund more prosecutors, we're going to fund more public defenders, we're going to have more judges. Okay, that could have been one response, and that's happened to an extent, but not as much as you would need for all the trials. The other thing you could have done that would have been more radical, I would love to see this, is that you would decrease the extraordinary volume of acts that are funneled through our criminal system. You might decriminalize some certain conduct, you might cut way back on so-called lifestyle enforcement. These are things like selling loose cigarettes. Remember Eric Gardner, who was killed? Yeah, that was lifestyle, quote-unquote lifestyle policing that actually recently the NYPD had said we need to go back to a little more lifestyle policing. That's how that incident actually ends up occurring, right? So you might, as an order in your policing, say actually we're going to lay off policing, that kind of stuff, or you might divert more crimes into civil systems, like DUIs, driving under the influence. You might say we're going to do civil remedies for that, maybe take part of your car or whatever, rather than doing so much in the criminal law. That didn't happen. Okay? We just said we just want to keep going, lots of stuff, even we criminalized more than we did now in the 60s. And so what we decided to do instead is to avoid trials more than ever and to rely overwhelmingly on plea bargains, right? There was no way that we could have longer, lengthier trials and at the volume and actually more than we criminalized in the 60s and keep the system going, and so we pushed instead toward more pleading. Justice Anthony Kennedy of the U.S. Supreme Court wrote in a 2012 decision, he was citing Bill Stunt's quote, "To a large extent, horse trading between prosecutor and defense counsel determines who goes to jail and for how long. This is what plea bargaining is. It is not some adjunct to the criminal justice system, it is the criminal justice system." Okay? So, on the one hand, we can totally understand why the statewide prosecutors want to avoid trials, right? Because then, they don't have to put up with these lengthy arguments, they don't have to put so much resources into trials. But notice from the viewpoint of the accused, on its face, it doesn't make sense to waive your right to a trial, probably, right? Unless you genuinely, quickly want to take responsibility in a good faith effort and avoid. But rationally, you might think, well, why don't they just go to trial, right? Why would you waive that right? Because then maybe you can make these arguments that it was an illegal search, or that the prosecutor can't prove their case beyond a reasonable doubt, right? At trial, of course, the defendant is presumed innocent. The burden is on the prosecutor to prove every element of the crime beyond a reasonable doubt, right? If I just plead guilty, they don't have to prove it all, right? And of course, the defense at trial doesn't have to disclose their case. If I have a star witness who's going to say I wasn't there at the time, I don't even have to tell the prosecutor. I just spring it on them and hope that the judge accepts it, and then, the case is going to go my way. So why then doesn't, as I say, every accused just go to trial? This is where we're going to return to this point about structural incentives and why there is really a stacked deck against poor, accused of color, accused who are marginalized, who have mental illness or addiction. So I'm going to argue that resources, in fact, matter more today than ever in explaining why so many people plead guilty without going to trial. And I know Christina is going to touch on this a little more, and I think we'll even tell maybe an even darker, in some ways, story when you get into the details of what you see, why people are pleading. The first kind of structural feature, though, that we cannot understate, or sorry, no, that I can't overstate, is pretrial detention. Okay? This is when you are being held in custody in a jail, that's what it'll be called, a jail, before you face trial, right? So you are legally innocent, but you are in pretrial detention. You want to think about the numbers. Nationwide in the U.S., there are about 750,000 750,000 people tonight will be going to sleep in jail awaiting trial. So these are legally innocent people who are going to sleep in jail. There are a few factors. I'm not going to go into all of them. Again, Christina may go into this a bit more. One of the factors is cash bail. You'll hear that there are reforms coming through in New York around this issue. There have been efforts in Canada. It remains a huge problem, even with reforms. If you can't afford to pay bail, or to pay really, really egregiously high interest rates to a bail bonds, man, you know, you go near any detention facility, you say bail bond. If you can't pay that, you're going to stay in jail. And if you're wealthy, you are going to get pretrial release, right, often. What does this mean for the accused? Well, even a few days, but certainly a few weeks, and absolutely a few months in pretrial detention will mean that you will lose often your housing, you'll lose your job, you'll often lose child custody, right? All of these things in your life. You think if you went out to the store tonight and just disappeared for a few months, what your life would look like when you tried to return back to it. And often it has fallen apart. It's also extremely difficult, obviously, to defend yourself from jail. It is really hard to schedule meetings if you have a public defender, legal aid. They have a million other clients. It's hard to get them to come in to see you. It's hard to work your case up or anything else when you are sitting inside a cell without access to resources. So what do? People are intensely incentivized in those situations to plead guilty to get out. The easiest way they see to get out in the morning before their life completely implodes is to plead guilty, regardless if they are factually guilty, and regardless of whether they may be, when I say factually guilty, like did they do the act, they may even have done the act, but they might have a valid defense if, the police searched them illegally and shouldn't have got that evidence or some other defense. The quickest and easiest way, though, for them to get out is to plead guilty. The other thing structurally about this, a lot of the bargaining chips at this point, and I know I'm wrapping up in 1 to 2 minutes here. The prosecutor can do many things to force your hand, right? The first is that they can withdraw some charges in exchange for a plea. They can accept a plea for a lesser offense. This is all part of what we call charge stacking. If you have any type of often wrongdoing act, if you look at criminal statutes, they are super overbroad. They have all sorts of overlapping offenses. So I can say, Alice came in here and she, went off with X, Y, or Z piece of property. I could probably charge you with 5 different, maybe I'm exaggerating, but at least 3 different counts. I can charge you with this, I can charge you with a felony, I can charge you, I can charge you with different types of crimes. So it's a whole series of crimes that I can charge you with. And what I'll say to you is I'll say, Alice, if you plead, I'm only going to charge you with this particular robbery offense, I'm not also going to charge you with B&E, I'm going to, you know, and that's called charge stacking, right? I'm going to charge you with 7 or 8 things, knowing that you are then afraid that if you don't plead, you're going to be convicted of all 7, and you're obviously going to face a really lengthy time. The other thing is the so-called trial tax you'll hear people talk about. This is that if you say, no, I have my rights, I think this evidence was illegally obtained, or I didn't do this, they'll say, fine, I'm going to offer you a year, I'm going to offer you 6 months or something, but if you go to trial, I'm going to push for 10 years. Right? Now think about how risk-averse or not risk-averse, and who is more likely to take that risk than less. If you are poor, if you are a person of color, if you have mental illness or addiction, if you're indigenous, and you have a legal aid or a public defender, are you really going to sit there and think, yeah, I think this is a system that I'm going to bank on, that I'm going to go to trial and possibly face 10 years versus a year? Right? That's what we call the trial tax. And I'll just end with this before I have a final wrap-up. This is kind of puts it, I think, in stark relief. The executive director of the Innocence Project told journalist Emily Yoffe in a piece for The Atlantic, quote, "Our system makes it a rational choice to plead guilty to something you didn't do." Right? Based on the kind of quick glimpse I've seen, you can see it's not irrational. People often say, well, why would people plead guilty to things they didn't see? Well, once you see how this interlocking set of actors and institutions work, it actually makes a lot of rational sense, particularly when you are a more vulnerable actor, which is who most of the people in the system are. I'm going to skip to the end, and I'm just going to, because we are kind of here in a faith setting, to think about why should we care specifically as people of the Christian faith about this issue. And I want to say for me, and maybe for others here, I really think that the criminal law system should really be a fundamental part of anyone's theology of life. I think if you're thinking about life issues in a holistic way, this should be very much central to that. In 2018, even as the U.S. hit a 9-year low in its prison population, it remains to this day, the U.S. has the highest incarceration rate in the world. There are more people warehoused in this country in custody than any other country in the world. And I'll end with some words of what Pope Francis has recently suggested, how we might think about this, and it'll return us to this issue of the criminal. So recently, Pope Francis was speaking to participants at an international meeting of people working in the prison ministry. And he said, quote, "It is easier to repress than to educate." And I would say it is more comfortable too. Denying the injustice present in society and creating these spaces to put offenders is easier than offering equal development opportunities to all citizens. And he concluded his talk with them by sharing a story that he has shared before, and this is when he used to drive in Buenos Aires. He would drive often past a prison, and he would see the lineup of people waiting to visit the inmates, right? And we can often, I think many of us probably know a little intuitively, who overwhelmingly visits inmates in prison, and it's their mothers. He would see mothers of detainees who would arrive early. They would undergo often humiliating security checks, and he said, "May the church learn motherhood from these women and learn the gestures of motherhood that we must have for our brothers and sisters who are detained." So to return to our opening about who is the criminal, remember, to each and every one of these mothers, the criminal is always their child. Thank you.
So, like a true trial lawyer, no notes, all off the cuff. But there are some things that I do definitely want to hit upon. Plea bargaining, because it's a big part of what I did when I was a criminal defense attorney. I want to talk about the rights that she was talking about your right to remain silent, about statements being thrown out, and evidence being thrown out. Yes, in theory, academically, that is how it works. I'm going to give you a more boots on the ground view of how that really plays out. I also want to talk about bail and how that affects the decision whether or not to go to trial. And I also want to talk about my view as a Catholic and how that informed my decision to become a defense attorney. I grew up in a very heavily police neighborhood. I grew up in the Mott Haven section in South Bronx. It is the poorest congressional district in the United States. And when I first graduated from law school, represented the people of Mott Haven. I worked in Bronx Criminal Court. Which made things really awkward. But at Mass, I remember once at Mass I was online for communion, and I felt someone tugging at my sleeve, and I looked down and it was like the mother of one of my clients, and she said, "I'll talk to you." But you would think, right, because I grew up in that neighborhood, that I would have gone into my profession as a criminal defense attorney eyes wide open, totally aware of our criminal justice system and what the criminal looks like. What, we did that exercise in the beginning where we imagined what a criminal looked like. I actually also evolved in my thinking through working in the criminal justice system. The criminal looks like you or you or you. We are not our mistakes. And people do make mistakes, particularly in heavily policed neighborhoods like the South Bronx, like Brownsville, Brooklyn. I've only practiced in Manhattan, the Bronx, and Brooklyn, so I can't tell you what the neighborhoods are in Queens. But particularly in those neighborhoods, you're going to find people caught up in the criminal justice system, and they're people. They're everyday people like you and I. But we often create this wall, this barrier that makes it difficult for them to enter into society. But let me go back to the beginning, to plea bargaining. I was a criminal defense attorney for 6.5 years. I now work for criminal court judges. I'm neutral now. I do the research, I do the writing, I advise judges. I don't have clients anymore. But for 6.5 years, I was a defense attorney. And in those 6.5 years, I tried as first chair 14 cases. I participated in other trials, when I was less experienced as second chair. But even that didn't total maybe 30. I handled thousands. I handled thousands of cases in 6.5 years, but I only tried 14. And there's a lot of reasons why people will decide to take a plea. And some of them are heartbreaking, especially if you were like me, speaker, beaver, law graduate who wanted to save the world. And you find somebody who's taking a plea because, I just can't keep coming to court. I cannot miss work. All these court dates, I can't do it. I'm going to plead guilty. And I would spend a lot of time in the beginning trying to talk them out of it. But the reality is they have to feed their kids, they have to pay the rent. And if they are in court fighting the case, as an attorney, I get vacation days. I had floating holidays. The vast majority of my clients didn't. If they didn't go to work, they did not get paid that day. So, it took a while for me to realize that my argument, that I was coming from a very privileged position by telling them, no, you can't plead guilty, you have to fight the power. It cost them a lot to fight the power. So I would sometimes have to plead out people who, in my heart, I believe were innocent, because they couldn't keep coming to court. there were people who would take the plea because they could not afford to spend time in jail. Bail would be set, and oftentimes, you know, I had a lot of homeless clients who would say, look, I just got into the shelter, if I'm in jail, I'm going to lose my bed, I'm going to lose everything, I worked so hard to build this, I can't do it, I'm going to have to plead guilty. And even if in my heart of hearts I believed he was innocent, or, you know, if I believed he had a strong defense, it didn't matter. I would have to plead this person guilty because, just because of the way our system works, that really was what worked best for this person. This has a lot of power in plea bargaining. And in New York State, I'll be talking specifically about New York State because it's the only place where I practice. New York City, actually, is the only place where I practice. The law in New York used to be that they did not have to hand over any police reports or anything to me until the day of trial. I wouldn't know how strong or how weak their case was until we went to trial. But if we went to trial, then whatever offer they made my client, especially if it was a non-jail offer, like probation or something like that, would be off the table. And I would have to present that to my client. You know, I don't have the police reports, I don't know what they got, but this is their offer. Do you want to take it or not? And you know, after 6.5 years of that, I was done. I was done. It wears on you. But it was even harder on my clients. Plea bargaining is a necessary thing. From the perspective of the system, yes, there are too many cases. If everybody went to trial, it would break the criminal justice system, but it would also break the criminal defendants, because that means they would have to wait even longer before they actually go to trial. That would mean even more court appearances. So just the way our criminal justice system is set up, without the plea bargaining, it just doesn't function. One thing that Lisa mentioned was the increase in rights, right? The police can't just bust into your apartment and, you know, say they found drugs. That stuff would have to be suppressed. It can't be, you know, they can't use it at trial, in theory. The reality is that what a police officer says has so much weight. It is so hard to convince a judge that what this police officer is saying is not actually what happened. It's a little easier now with body cams, now that they have body cams in New York City. But even then, they can shut off the body cam. You know, they can turn off the sound. They still have some control. It gives you a little bit more to argue with, you know, like if the body cam, you know, they shut it off at some suspicious moment. But you still have to convince a judge that this police officer, you know, law enforcement with his badge and his shield and his uniform, who just swore to tell the truth, just lied to you. So yes, things can get suppressed. They often don't. Hearings were just a way for me to get some of the discovery that the district attorney's office wasn't willing to, or isn't willing to give me until trial. It was like my opportunity to get a sneak peek of the evidence. Very rarely would we get stuff suppressed. Bail. How many people have heard, oh right, collateral consequences of these convictions. How many people have heard about the bail reform law that's happening in New York City? What have you heard about it? What kind of stuff have you heard?
Basically what she summed up earlier. I didn't have too much on page.
Have you read any articles that are like, Alice, have you read anything about it that's given you some kind of impression about this?
Well, you know, it sounds like a very good thing that they would do away with bail, and that, yeah, I mean, that's all I know.
Well, there is a segment of the population that's really pushing back really hard, mostly law enforcement, prosecutors. If anybody needs to do it, post. I got a message from a friend the other day to ask me to explain why the court system is giving criminals mess tickets in order to lure them to come back to court. I can assure you that's not happening. It's the way that the more conservative pro-law enforcement side is spinning things, you know? What really happened was there's an agency in the mayor's office called the Criminal Justice Agency that oversees many aspects of the criminal justice system, but particularly the things that happen pre-trial. They make determinations or they make suggestions as to whether or not someone should be held on bail or not, and things like that. They have a team of social workers that works particularly with young people. So what happened back in July, the Criminal Justice Agency, some social workers of the Criminal Justice Agency singled out 6 teenagers, no older than the age of 18, 6 teenagers who made all the court dates, who went to all the programs they were instructed to go to, who were receptive to suggestions and worked with the social workers. If you work with young people, that's a big deal. To get young people to be that cooperative. So they rewarded these 6 kids with a trip to Citi Field. Tickets that were donated by a philanthropist, no tax money involved. And the New York Post sees this as crook coddling, and they're giving money, they're giving away these things to these criminals, but they're not giving anything to the victims. When in reality, it was a way to incentivize these 6 young men to just keep doing what you're doing. You're doing great. And in our system of justice, that's seen as coddling by law enforcement, by prosecutors. It's seen as coddling. It's not. It's just a way to encourage young people to continue to do the right thing. And once you get a criminal conviction, it kind of labels you. It stamps you pretty much for life. There's consequences to having a criminal conviction, and there's some consequences that aren't obvious. Some people know that if you have a drug conviction, you may not be eligible for certain financial aid. If you later get your life together and decide you want to go to college, it's going to be a little hard to pay for if you've got a drug conviction. Some of those things are widely known. But there's lesser known things. Like, did you know that you need a license in New York State to be a barber? And if you've got a criminal record, you cannot have a barber's license. Sure, I know people who, do stuff under the table, but if you want to open your own barbershop, if you want to work someplace else, you don't have that license that you can take with you that, can help you bargain for a better salary. You can't be a barber if you have a criminal conviction. To sell bingo supplies in New York State, you need a license. And you cannot get that license if you have a criminal conviction. To deal with alcohol, to work at a bar, you cannot have a criminal conviction. If you want to own a bar and your spouse has a criminal conviction, you have to put that on your application. That might affect your application. There's so many barriers that we as a society put for people who have committed crimes, who made mistakes in the past. And I challenge everyone here to, let me tell you the story. So, we all know the story of his case, right? He was tax collector. Tax collectors back in the day, like, they were very popular. No one liked the tax collector because they worked for, the Romans, they collected the money, they sometimes weren't very honest. So there's this tax collector named Zacchaeus, who's a short guy, who wants to see Jesus. But he's short, and there's all these people up in front of him. So he has to climb up a tree to see Jesus. I once heard a priest describe that group of people who kept him from seeing as a wall of righteousness. Like, there's this wall of the righteous that was keeping Zacchaeus from Jesus, and he had to climb that tree. He had to go the extra mile to see Jesus. And Jesus sees him and says, Zacchaeus, I'm going to have dinner at your house tonight. He reaches out to the most lowly of everyone in that crowd. If we're going to be the hands of Jesus in this world, then we're the ones who are going to have to reach out to Zacchaeus, right? We're the ones who have to break down that wall of righteousness and give people a shot. And that's pretty much what's happening now with bail reform. Trying to even out the playing field so that judges no longer really have a discretion when it comes to misdemeanors. You have to release them. And that bothers a lot of people, especially judges. They don't like for you to take away their discretion. They love their discretion. So, but now, the white kid from the Upper East Side and the Puerto Rican kid in Harlem are both going to be released. That wasn't always the case. A judge could determine, well, this kid doesn't, his parents aren't here, it's happening on school nights. I think he needs to be held. A judge can't do that anymore. And that is a positive thing. But it scares a lot of people. Don't let it scare you. Because this bail reform law, it's a huge change. It's like a very scary time to be in criminal justice right now. Particularly if you have experience, if you came from this old way of thinking to this new way of thinking that is more rehabilitative than punitive, and that it really tries to give people a chance. Don't let that scare you.
Questions? Christina, I remember the very first time you told me what you did for a living. I looked at you like you were crazy, and I thought, ew, geez. And then you proceeded to tell me why you did what you did. And I was in awe of how much you cared about doing the right thing for these people who deserved fair treatment. Do you remember that conversation?
I do remember that conversation. Father Kelly was there too.
Can you say a little bit about that, just to let people know how what your thinking is about why criminals deserve a good defense?
Well, I remember telling you that it is so easy to point the finger and accuse people, and it's so easy to point out everyone's faults. Like, you did this wrong, you did that wrong, you did this wrong, and it's much more difficult to forgive, and to create a space where a person can make a better choice. Over time, I realized that really is the essence of forgiveness, really, to give somebody the opportunity to make a better choice. Without the prejudices and all the baggage that we put on people because of the mistakes they've made in the past. That's the harder choice. And Jesus didn't give us an easy way to do things. Like, he wants us, oftentimes it's the harder choice, right? It's the harder choice and it's the better choice because it makes for a more cohesive community. And really, if we personally were judged, if God judged us the way our criminal justice system judges people who come into the system, Oh my goodness, I don't know where we would be.
I'm curious, I just want to be clear. You're saying that when someone has a record, anything they're going to do basically that involves a license, for the most part, they won't be able to get that?
Well, there is an avenue. There's something called a Certificate of Relief from Civil Disabilities, but that's not guaranteed. And there, the judge has all the discretion. You know, I've worked for judges who would routinely sign them. I currently work for a judge who doesn't. Like, I have to advocate, you know, like I have to become a defense attorney again and get him to give the person an opportunity to rehabilitate themselves. And he puts them through the ringer. Like he makes them continuously come to court. He makes them go through a probation interview. It's not a guarantee that you'll get that Certificate of Relief of Disabilities, and it's not a guarantee that they still won't consider your criminal conviction. It stays on your record. The Certificate of Relief just indicates that you have made some choices in your life since then to turn your life onto a better path, and that the court recognizes that. So it is possible that you can overcome that hurdle with a Certificate of Relief, but it's not guaranteed. It makes it more difficult.
But for the most part, you're saying that if you have a criminal record and you want to conduct business that requires a license, that for the most part, you won't be able to?
It depends. Like, there's a website. It's put together by the American Bar Association that lists all the collateral consequences in each state of a criminal conviction. And you could check to see if whatever license it is that you have in mind in particular, you know, has some kind of a barrier to people who have convictions. So it's not everything, but it's some obscure things that you wouldn't imagine, you know, would require a license.
What about people that commit like egregious crimes, like maybe when they're younger, or like, you know, like killed 5 people when they were like 20 and they're in prison for 30 years and they claim to be reformed? Like Leslie Van Houten, who was in Charles Manson's cult when she was like 19 when it happened, and she's been up for parole like 15 times and they continue to deny parole. What are your thoughts on that?
My thoughts on violent crime are a little different than non-violent crimes. Most of the people that go through the criminal justice system are not there for violent crimes. They're not like the worst criminal that you imagine in your mind. That is a very small fraction of the people that I came across, and you know, the people statistically that are in prison. People like that, like people who continuously commit violent crimes, that's what prisons are made for, you know, to keep us safe. However, the vast majority of people who are held in prison aren't those types of criminals. Those are the people we imagine, but that's not necessarily who's being held.
My question goes to the preventive side of all of this. I mean, Christina, when you work with these individuals, what were the circumstances that led them to these nonviolent crimes?
It's kind of hard to answer in the abstract.
That's okay.
You know, because it really, I think underlying most of the cases I handled anyway was poverty. Right. You know, I handled an extraordinary number of drug cases. And a lot of what led to that was poverty. You know, I had a colleague who represented he wasn't a teenager, I think 19, 20-year-old, who was selling drugs to keep his little brother and sister out of foster care. Mm-hmm. You know, there's heartbreaking stuff like that. Poverty, I think, is what was underneath a lot of what I dealt with.
So how do we fix that? That's a rhetorical question.
That's a
And I
big
just
question.
add that as well to what Christina said, which is just, I guess, to also like have us also think about the premise of the question, which is that we still tend to talk and think that certain groups and communities are more, I mean, the language they use is more crimogenic, more likely to commit crimes maybe than others. But the more that you look at the kind of structural way that the system bears down on some communities than others, you quickly see that, I mean, drugs is a great example. I mean, in many places, white people statistically by far use as much and often more drugs than African Americans, Latinos, indigenous people. And yet the statistics in terms of who actually gets surveilled and caught and channeled into the system are totally different, right? So, I mean, you think about, for instance, like how drug crimes, who gets caught and who doesn't. So if you're wealthier and you're white, you will tend to have your drugs delivered to your home or to a inside location, because then you can't have police who see a hand, like you often need for a drug crime, at least in Canada it works, the police often need to see a hand-to-hand transaction, right? So they have to actually see the drugs in order, if it was ever to go to crime, they need to see a hand-to-hand, unless they actually get in and get the drugs, right? But if it's just a sale, well, of course, if you own your home and you're more connected, you will have the drugs dropped off to you, right? If you're a lower level seller or a street-based user, you're going to do it much more in plain view, and you are much, much more likely to get picked up, right? So it's not as though, well, that set of people are doing more bad stuff and more criminals, and do we need to interrogate, all of that? Which is also true, of course, about poverty and everything else, but it's also that the system so disproportionately bears down on people who are poor, right? Like when we walk home tonight, you're going to see, those big strobe lights of the NYPD that are situated in front of social housing, right? I don't know, I'm probably putting it the wrong way. But they aren't going to be, the NYPD is not going to set up strobe lights on Park Avenue in front of the doorman, right? You don't think that there's lots of coke and everything else that's getting delivered right into those Park Avenue places? Absolutely. So there's a big, you see the same thing in schooling. I'm doing a project right now on police and schooling. The police, they get assigned to black and brown schools. So there's a kind of a chicken and the egg thing.
Thank you very much for your time. And I want to follow up a little bit on her comment, because from my experience, what I've seen and what I personally experienced is that it's very easy to activate the criminal justice system against anybody. That's without even a fact, right? It just happened and you are into it.
Yeah.
And it's so complicated to get out
Yeah.
smoothly, like the way you imagine to do it, like in the TV show, right? So when did that happen? When it became so easy to accuse someone and put them through the criminal justice system, a system that is so difficult to get out, and it requires so many resources and time, and is so complicated?
One issue, I don't know, this is probably not what you had in mind, but one issue, and this is a controversial one, is the area of domestic violence. So it used to be historically, kind of up until the 70s, often people would call the police may or may not show up, and when they did, they would say, well, this is largely a private matter, and you should go back and resolve it yourself, right? There was then huge feminist advocacy to say we need to take domestic violence seriously, treat it like a crime as we treat all other crimes, because otherwise women are left to battering situations unfairly, right? Interestingly, though, what has happened is that many, this certainly occurred across Canada, occurred in New York, many prosecutors' offices and police forces adopted what we call no-drop policies. That is that if you are called, as you say, and that 911 call happens and they get there and there's any kind of inkling of domestic violence, which is also the definition of domestic violence has broadened over the years, you're going to be engaged into the system, right? And it was correcting against certainly huge historical problems of not policing it at all, right? And leaving people, you know, bruised and battered and saying, solve this in your family, right? But one of the concerns has been that what you're articulating, that once the system gets triggered in those kind of cases, it is extremely difficult, especially around the issue of domestic violence, to shut it down at all. So what happened was many feminists said, well, women might say, well, I wanted to call the police to stop this actual instance of violence, but I don't want my partner, my boyfriend, or my husband to actually get criminally charged and to go through a system and get a criminal record, right? Maybe I have an ongoing. Some feminists said, well, these women are just really afraid and they're so battered they aren't going to, because they're afraid that he's going to re-batter them. But this has now become a serious issue of debate amongst feminists, amongst different people, especially in communities of color, where many people don't want this to become a full-blown criminal justice process right through to the end. The other thing that's happened is that if the police arrive at the scene and there's any kind of mutual contact, like he has, you know, pulled the phone out of the wall, which can be considered in some interpretations as a form of domestic violence because it's threatening that she can't use 911, and she has slapped him across the face or something, what they do is they arrest both. Both are then channeled into the criminal system because you have no drop, and you say we're going to do no drop policy against both. And then sometimes they get into the system, this happens in New York, and then the judge orders he's going to go on trial, or he gets charged or gets found guilty or pleads or whatever. And as a part of the sentence or even pre-trial, they'll say, we are going to impose a no contact order, even if she doesn't seek it. And I'm using he and she because it's generally been in a gendered paradigm. Then that might mean that if he goes back to that apartment, even though they might have kids together, she may invite him back, he's then in contravention of his no contact order, and he can be rearrested. And you actually have cops that go around and surveil, again, predominantly housing projects, and they're checking for men who are on domestic violence no contact orders, who have been invited back into the apartment because it's part of their family, and they find them there, and then they get them as contravention of their conditions. Now they're going to have more charges. So that's another example of where there's these perils of reform, right? In terms of when you decide to engage the criminal system more for social problems, it's very complicated.
Just want to thank you ladies so much for just excuse me, giving so much insight, you know, into the criminal justice system, and as you mentioned with the like the due process and our rights. There's actually 2 books that I just started reading, so there's not much I can really glean at the moment out of it, but 2 books that I've actually started reading about criminal justice. One is called, and it kind of ties into the mass incarceration, one is called The Meaning of Life. I forgot the authors, but it's The Meaning of Life and Unusually Cruel, and it basically talks about, you know, how punitive the criminal justice system is here in America. And what's interesting, and Christina, right, you said you mostly deal with non-violent offenders, and it's actually interesting as you brought up, like, you know, people who have done violent acts. And it's interesting because some of the thus far in the chapters that I've read in the books, they've even said one of the things of trying to address mass incarceration, because if I'm not mistaken, a lot of people are incarcerated at the state level.
Yeah,
One of the things
majority.
Eventually you would even have to consider people who have unfortunately done violent crimes, such as rape, such as armed robbery, murder and stuff. Because even, you know, even though they're egregious crimes and they should be held accountable, even the worst of sins, people can genuinely reform themselves. So what, I don't know if it was in the book or if I went on the website, but they've actually advocated, because they've said even in countries like Norway and I believe some other European countries, the cap, regardless of the crime you commit. Now, I don't know if it's like, you know, let's say someone does a crime against humanity like 9/11 or something, of course they can be in jail for life. But what they've said is that in most European countries, they put the cap at 20 years because they feel that, let's say, you know, 10, 15 years, I think there's even studies where people could age out of their criminality, like, you know, as they get older compared to in their 20s. And I think they've said that fiscally and morally, once the person has not shown any like bad behavior in prison, or this person has genuinely tried to make amends or reparations for their wrongdoing, the cap would be 20 years. Do you feel that's something that, and realistically, like maybe in our lifetime, especially as the United States is, at least under a presidency, a bit more like law and order, do you feel something like that could realistically happen to reduce our incarceration rate?
This is such a great question, because I'm so glad you raised it, because this distinction you're talking about, so under President Obama, right, he was really rightly celebrated for being, I believe, someone can correct me, but I'm 99% sure this is right, for being the first sitting president to go inside to visit prisoners, right? And this has been a big talking point in the kind of common ground right now between the right and the left for resolving mass incarceration, that if we address the non-violent drug offender population, we'd see a huge downtick. But you're absolutely right. To really have meaningful reform numerically, but even on a deeper level socially, I don't think you can shy away from those who are classed as the violent offenders. And remember, violent, yes, is going to include up to murder, but it's going to include a whole host of things, right down to what most people are coming in the system is common assault. And it's not like assaulting someone to, some regular, like a small fight or a scuffle that otherwise might have been swept off, but if they're in the wrong place at the wrong time and they're the wrong color or whatever, they're going into the system, right? That's all counted as violent. I agree with you that, the talking point of limiting to non-violent drug offense, I think, is a trap if you're interested in a more radical revisioning, right? And on your point about aging out, I think this is also a hugely important point. There's a new book that just came out in Canada by a colleague of mine called, I think it's called Punished for Aging. And it's Canadian, but I mean, there's very similar numbers here. And it's addressing how many of our prison population are old, elderly people. And as you say, obviously the statistics show 75-year-old men are not, if they're released, going to be running around committing, mass horrendous crimes. I mean, maybe they're going to commit white-collar crimes, which maybe we should take a little more of a look at, but they're not going to be running around doing the things that we are concerned in our mind about, right? And instead, many of them are, they're getting they have all these heart disease, everything, their mortality rate, they have high rates of TB, there's HIV, everything like this. And I think thinking seriously about caps, will that happen in our lifetime in the U.S.? I mean, maybe, but I think you are absolutely right. I think we have to be serious in going there. And I think it's a trap, if you're kind of interested in seriously engaging on this issue, to stop at, we're only going to touch nonviolent drug offenders. I mean, maybe that's where we'll get to in our lifetime, but you have to reach for the stars, to whatever the phrase is.
Yeah, I just wanted to make a distinction between like what the law considers a violent crime and what the average person imagines in their mind to be a violent crime. When I was talking about only a small percentage of the people in prison being violent criminals, I'm talking about what people generally consider to be a violent crime. Like in New York State, if you are with someone, let's say Griffin and I go out drinking and he gets a little excited and decides he's going to rob somebody, and I'm too drunk to know any better, I'm hanging out with Griffin, that's a violent crime for me. It's because it's aided. Rob to aided means that there was more than one person involved, so it becomes a violent crime. That's not necessarily my idea of a violent crime, but the law defines it as a violent crime. Things like stranger rapes, things like first-degree murder. That's a very, very, very small percentage.
Exceptionally rare.
Of the people who are in prison, and that's what people imagine when they think of a criminal or when they think of violent crime, like felony murder, which is what you were describing, what that woman did. That is not what the average person would consider a violent crime, but it's what the law considers a violent crime. So I just wanted to make that distinction. Father Kelly?
Both ended, interestingly enough, with a scriptural or a church quote, Pope Francis and our friend Zacchaeus. So your faith has influenced your ethos, how you enter into it. One of the things that comes out from the conversation, see the presentation for me, is that we seem to be hell-bent in this country on punitive justice rather than restorative justice. Yeah. Of course, the Catholic tradition is all about restorative justice. But it also seems to me that what I'm hearing from both of you, and correct me or add on to it, is that aside from this very small percentage of people who've committed violent crimes, we have created as a society a system that in some ways is profiting from punitive justice.
That's another issue.
I mean, the prison system upstate is providing people with jobs and all sorts of things. It's keeping the whole thing and all sorts of stuff. How do we as a Christian community, I know Kathleen was talking about before, we were very active for many years as a parish in Harlem at Drop the Rock, trying to get rid of the Rockefeller drug laws because they were so draconian. How do we add our voices to a different way to be a society? And to look at the sickness that's in us, to not want to seek the restoration of a sinner or a broken person, but their destruction. So,
good question.
going back to Zacchaeus, how do we make room for him to get to Jesus rather than Jesus come to him rather than blocking?
One thing that I would suggest is to support organizations that promote re-entry into society, to create a community, like within our parish, within our families, where we have an understanding what it means to forgive as a society. I mean, it's a tough question because there's just so much pushback, like when these criminal justice reforms are moving towards, a less punitive form of criminal justice in New York, and there's just such an active push against it. So it's a difficult question for me to answer at this point because I'm in the midst of all the pushback, and sometimes it feels kind of hopeless.
I'll just add to that by saying, I mean, so that it doesn't sound like a total downer, which is that I think there is a real opportunity right now, and it goes a little bit also to your point. Sorry, what was your name again? Brandon, about the fiscal point as well. And you are starting to see, I mean, certainly in the Democratic, party and on the right, you're starting to see people saying, well, you have to have a position on criminal justice reform, right? And part of it is because the punitive policies, more and more people across the aisle are seeing the punitive policies have not delivered, even on their own terms, right? More and more and more people are finally recognizing that the Rockefeller, the war on drugs, generally hasn't delivered what it was supposed to on its own face. That fiscally, yes, it does create jobs, but it's also, I mean, the U.S. spends much more on the corrections industry than it does on education, and I think finally people in different stripes are starting to say something has to change. This status quo is no longer appropriate, and I think in those kind of conversations, whether it's in the magazine or in the parish or in our work, being part of those conversations to say yes, and there is an alternative, because I think there is a more realization that's happening right now that the current last several decades has not worked. And one person who I really like, I mean, his work is amazing, is Brian Stevenson, who is the head of the Equal Justice Initiative. He's he's a prof at NYU, a long-time death penalty litigator against the death penalty. He's now founded the first kind of museum and monument to lynching in Montgomery, Alabama. And his book is called Just Mercy. I want to say it's called Just.
I have that book too.
Yeah.
It's being turned into a movie.
And it's being turned into a movie, yeah. And he writes, so Stevenson writes in there a lot that at the core, his understanding is that when we recognize our own brokenness, that is the touchstone for our humanity and our human connections to others. That what unites us is that each of us is broken, and that each of us can see the other in their brokenness. And when we acknowledge the brokenness and the darkness in ourselves, we will seek out the compassion of others, hopefully, and the connection of others. And the prayer then for him and his whole life's work is about extending that same level of compassion to the other. And that happens exactly through restorative justice type work.
So I'm just mindful of time, it's about 10 to 9, and we're certainly welcome to stay and ask some individual questions, but we wanted to take a moment to thank you guys for a wonderful presentation.